I want us to look at torts and crimes. I call this negligence, the reasonable person. That's basically the foundation of all tort conduct is what would a reasonable person do under like or similar circumstances. Torts are civil wrongs, auto accidents, your sidewalk is not properly maintained, or you shoveled the walk but didn't remove the ice. A variety of things, a large and always expanding universe. So, what we want to look at is what we should have known, all right? What we knew or what we should have known. Um, we basically have a duty of safety for ourselves. Watch out for myself, watch out for other people. Look at whether other people are doing something crazy. If they're doing something crazy, we just cannot go encounter them. We need to take care of ourselves and go, I don't need to get near that. Somebody's weaving as they drive, somebody's texting as they drive. We've got a duty of due care for ourselves that's going to actually come over the fact that, yeah, they were driving nuts, but I knew they were driving nuts, so therefore I took evasive action. All right. When we look at what we knew, we need to understand that as business entities or people inside business entities, we will be charged with all the knowledge of our employees, whether they told us about it or not. We're just going to presume in the law that businesses have enough sense to set up systems where employees tell them, hey, there's a slow leak out of one of the vents out in the dining room, and there seems to be water accumulating there periodically. So we can go check it, okay? Because if we knew that, or we should have known that. So what should have known? Did we do regular inspections? It's also, as I make an action, as I do things, what are the possible consequences of this? If I dump my chemical effluent into a river, what are the possible consequences to everybody downstream of me? I'm going to be held to that. And the other reason, and I think I've said this in other lectures, that we talk about what we should have known is that people will always go, unintended consequences. It's oftentimes associated with the progressive political agenda. Well, we didn't know that insuring everybody would drive the price of medical care through the roof. Well, they should have known that. They should have known that their models were flawed. Maybe politicians can get away with it, but businesses can't. We're going to be able to walk in and have a jury tell us what we should have known under like or similar circumstances. Okay, so again, employees have a duty. So you as an employee have a duty to, if you see something, say something. All right? The general duty in negligence is a duty of due care for ourselves. This also extends out to a duty of due care for others. And I can't stress again that the standard is you knew or you should have known. So let's look at a couple of other torts in a general fashion. Battery and assault. All right? Battery is least non-consensual touching. I'm one of these touchy-feely guys, but I've had to moderate that in a classroom. I would technically be committing a battery. Now, let's then talk to the next part. What are the damages? Well, if I touch you gently and don't cause any physical harm, nominal damages. You might be able to sue me and get $1, $10, something like that. There is something known as the eggshell plaintiff, that if I touch somebody and they fall over and then they break their knee and all kinds of nasty things happen as a result, I'm liable for all of it. Okay? So, even though I'm kind of a like to lay my hands on you and say good job, I modify my behavior. I'm not perfect at it, but I'm a lot better at it. So battery is least non-consensual touching. How do we signal consent? Verbally or in writing is best. Some people will kind of welcome it. People put their hand out to be shake. Technically that could be a battery but they put their hand out, I might shake it. I think it's probably a mistake in Western culture. It's one of the ways we pass all these germs around. But anyway, now assault, on the other hand, is not actually a touching. It's reasonable apprehension of harm. I pull a gun out and wave it at you or point it at you. I've committed an assault. Or the standard is I can walk toward you swinging my arm, but there's some point where I get within your reasonable zone of safety. Most of us have, 2 to 3 feet around ourselves. We would rather not, in most settings, be bumped into, have I committed a battery if I bump into somebody in the hallway going, maybe I should always check, but the hallways at colleges are oftentimes crowded and people come out of rooms, blah, blah, blah. Have we really committed one? There's a difference between technical and real. Do I get to expand my zone of harm? No, it is only that which, now we got doggies barking, so I'm probably got my doggies will be barking. So let's focus this back. What are we looking at? We're looking at reasonable apprehension of harm. Does that sound like a subjective standard or an objective standard? And remember, subjective is me. Objective is the 12 reasonable people on a jury. The answer is it's an objective standard. One of the areas that businesses always have to worry about is defamation. One of the things we do is people change jobs. They need some kind of information about what kind of employee was this. What most modern businesses seem to have settled on is, here's date of employee, here's jobs held. If we get a consent form signed, we can tell you salary. But you're going to have to jump through hoops to give that, and we're not going to say anything about this employee, period. Because words can be turned all kinds of different ways, and particularly if we're doing this in writing, we may commit a libel. This person was terminated for cause. We've opened ourselves up for all kinds of things, so that's why in the business world, about all you're going to get from anybody nowadays is termed days of employment. There is a statute in the state of Missouri that would appear to require more, but the last time I looked at it, it was filled with so many loopholes. I'm not certain it's as powerful as I was originally taught it to be. You may want to, this is something, if you're operating in Missouri, you may want to look it up, if it's important, if you're on the HR chain, or, there are ways around it where you actually have to say, was this, what was this person like as an employee? I think you get yourself into some big problems there. You're better off with kind of a just the facts, ma'am. They worked here from this day to that day, and here are the jobs they held. So what is defamation? Defamation is an injury to somebody's character or fame, okay? And slander is spoken. That's Steve Bailey. He's the biggest damn fool I've ever known. Well, guess what? Truth is a defense. So, I may be dead in the water on this, but generally that's not a real nice thing to say about me. And if you've said it to somebody else, you've now published it. All right, you need to publish it. So if I mutter under my breath to myself, boy, that administrator, blah 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 blah, I haven't really slandered. Do I have to have intent? No, we would use that knew or should have known standard, that I knew that muttering under my breath in a crowded hallway, somebody's likely to hear that, and that's likely to be recorded. I don't have any defense there. I don't have to have intent. I can do this negligently. Libel is written. The problem with written is it's much harder to deny that you did it, because there it is in plain language. Time Magazine plainly published this. Okay. There's also something known as defamation per se, or which translates in Latin or in English to as such. Per se is as such. You know, there's I'm going to use a public figures, although there's a public figure exemption that's been carved into the law. I still think pardon me, that's a questionable ruling, New York Times versus Sullivan, that we can defame public figures with almost impunity. That I could say things about Ashley Judd that are just not very nice, that would be defamation per se, or she can say things about Trump that are nasty, and it's no big deal. It leads to a slightly less civil society, is at least one of the counter arguments. That I would think twice before saying something mean about the President of the United States. But if I were to say that, Hillary Clinton is a liar, thief, and a cheat, the only defense I then have is that in itself is very defaming. If I were to say that about this individual, this goes to her character. She's a liar, she's a cheat, and a thief. My only defense is that I could prove these to be true. And just sitting here, I think I can prove two of them. I might be able to prove the third, but I'm not sure. So I probably defamed her. And I've just published this. But guess what? I've got maybe an exception here where I've talked about this in a context. I probably shouldn't have used a famous public figure, but it's not my intent to tell you that this is true. I don't know. I'm just giving it as an example of truth. I'm going to leave this out here, and maybe she'll come sue me. I think the evidence is pretty strong on at least two of those, that there's some issues with her character. We sort of want true debate. We just don't want people to harm one another without cause or needlessly. So let's look at, let me see, that's not my last slide. All right. I've got a couple more things to do, and this is going longer than I wanted to, but the defenses. In ordinary negligence case, there's contributory negligence. In the old days, if I got into a car wreck and I was a little bit at fault, even if you were grossly negligent, too bad, I get nothing. I didn't take care of myself. So, it sort of reinforced the idea, you better watch out for yourself. We've now moved into a more of a comparative negligence fault type setting, where a jury determines, no, Bailey, you were 10% at fault and this other driver was 90% at fault. And so if my damages are $100,000, I get $90,000 from the other side. I've got to cover my own 10 grand. There's another doctrine, and we'll see this more closely in cases that do the mock trial, and that's assumption of the risk. Did I know walking in that this was a dangerous thing? If I'm using a table saw, I'm assuming certain risks. I'm assuming a kickback risk. I'm assuming, that sawdust might get in my eyes. We'll see as we do product liability, which comes, I think, a little later in the chapter in the book, or maybe it doesn't, that really the manufacturer needs to guard against this, needs to expand their thinking on this, open and obvious risks I'm going to be able to assume. Things that are latent, hidden risk, that's going to be on the other party. They've either got to warn me, or they've got to guard, or they got to take some kind of reasonable chance. Since I brought up product liability on the assumption that I don't have slides that think about it, strict liability is basically either negligent design or defective manufacture. So it's a defect system. There's a defect in the product. You know, this pen could be defective enough to cause injury. For instance, if the nib is sharp enough that I might puncture my skin with it. You know, it's got to be, you know, and some of it is, as a manufacturer, I actually have to anticipate some reasonable amount of misuse. You know, a knife is meant to be sharp, so if it cuts me, no problem. But if the blade gets dull or warped and it hurts me really bad, then maybe I've got a product liability case. That's either a design defect or a manufacturing defect or both. And we see a lot of assumption of the risk there in products liability, that we'd been using this product for a long time. We knew there was a risk there, and we continued to use it. We didn't do anything to guard against it ourselves. So we see comparative negligence fault in product cases too. One of the last documents is last clear chance. And using again my automobile incident, if someone's weaving around or crossing the center line at me, at some time I have a clear chance to at some point I have an opportunity, I have the last clear chance to avoid the problem. I don't get to just blindly steer into idiocy. All right. If I can reasonably get over on the shoulder and avoid the contact, I've got a duty to do that. If I can't, then I don't. You know, but this is all last minute. But the problem is juries tend to have 20/20 hindsight. We're charged with having 20/20 foresight. If that makes sense to you. The last one is proximate cause, and I just wanted to make sure that is the last one. And this is legal cause. We spend a lot of time on a great case, and I'm blanking on it, Paulsgraf versus New York Central Railroad. A guy carrying some firecrackers home from work is jostled on the platform. The conductor grabs for him, lifts him onto the train. Out of his valise comes some fireworks. Those fireworks explode and set off a series of events where eventually somebody bumps into a scale. The scale topples over onto someone. Is the New York Central liable? Well, what happened in that case, which is written by Justice Cardozo, who was at one point considered the greatest jurist in American history, but as we've looked harder at his opinions, we find too many flaws in them for him to keep that. He's really bad in property, for instance. He's an interesting man, and this case is very well reasoned and a great example of how to reason. You know, it's written like philosophers. But anyway, what we're looking for here is this action or omission to act? And I didn't cover that. An omission, a failure to do something, is an act. I chose not to do something. And that can get you in as much trouble as actually doing something. So, you know, if I drive 90 miles an hour during rush hour, I'm probably guilty when I finally hit somebody of, you know, setting in motion a foreseeable chain of events. For the squib holder or the New York Central, when the conductor grabbed that guy, they couldn't reasonably foresee that he's got fireworks and that those fireworks they could see that maybe if he had fireworks, people would be startled. They might fall into the scale. The scale may not be adequately secured against that sort of thing, although I would argue that, you know, the scale should have been better secured because there is going to be jostling there. You know, could we see that the conductor had that clearly in his mind? This tends to be a legal question for the court to determine. So sometimes we may want to raise, this is outside of the proximate cause realm, Your Honor. Most judges are going to let this go to a jury, but if we've raised the issue, we've preserved the record on appeal, which is a big deal up in the appellate court, because if you don't raise the issue and give the court a chance to make an error on it, you haven't preserved the issue on appeal. So anyway, that's negligence and torts in a nutshell. Thanks for listening.